Okay, we're streaming live on YouTube. We can get started. We can go on the record. We're on the record in case number 9735, which is captioned Chaberton Solar Sunshine LLC's application for a certificate of public convenience and necessity to construct a 3-megawatt solar photovoltaic generating facility in Carroll County, Maryland. This is the evidentiary hearing. Counsel, please state your name and the name of your client for the record.
Good morning, Your Honor. My name is Andy Flavin with the law firm Troutman Pepper Locke, LLP, and I'm here on behalf of the applicant, Chaberton Solar Sunshine, LLC.
Good morning. Power
Good
Plant
morning, Your
Research
Honor.
Program?
Assistant Attorney General Steve Tolson. I'm representing the Power Plant Research Program of the Department of Natural Resources.
Good morning, Your Honor. Andrew Meehan on behalf of Carroll County, Maryland. Good morning, Your Honor. Andrew Meehan on behalf of Carroll County, Maryland.
Thank you. And yes, our microphones are very directional, and you have to be pretty close to it. Thanks.
Good morning, Ruthie Herman on behalf of staff.
Good morning. Okay, are there any preliminary matters before we get started?
No, Your Honor.
Okay. I believe that applicant Exhibit 1 was already admitted previously. Is that correct?
Yes, Your Honor.
Okay. And then it's fine for you to read off your proposed exhibits per the exhibit list that you filed, but why don't you read them all that you would like marked, I guess, 2 through 37?
Yes,
Read
Your
them
Honor.
all off at one time, and then we'll mark them and
Okay.
see if anybody has any objections.
Thank you, Your Honor. May we please have marked as applicant Exhibit 2 the cover letter and certificate of service for the application filed on April 22nd, 2024 under mail log number 309115. And may we please have marked as applicant Exhibit 3 the petition filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant Exhibit 4 the verification filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant Exhibit 5 the application appendix filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant Exhibit 6 the ERD narrative filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant Exhibit 7 ERD Appendix 1 interconnection documents filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant Exhibit 8 ERD Appendix 2 the Waters of the United States Report, Part 1 of 2, filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant Exhibit 9 ERD Appendix 2 Waters of the United States Report, Part 2 of 2, filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant Exhibit 10 ERD Appendix 3, which is the forest stand delineation, filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant Exhibit 11 ERD Appendix 4, which is correspondence with the Maryland Department of Natural Resources, filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant Exhibit 12 ERD Appendix 5, which is correspondence with the United States Fish and Wildlife Service, filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant Exhibit 13 ERD Appendix 6, which is the Phase 1 Environmental Site Assessment, filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant Exhibit 14 the ERD Appendix 7, which is the Geotechnical Report, filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant Exhibit 15 ERD Appendix 8, which is correspondence with the Maryland Historic Trust, filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant Exhibit 16 the ERD Appendix 9, which is the initial conceptual site plan filed with the application. Or excuse me, I apologize. It was in an updated conceptual site plan filed April 29th, 2024, under mail log number 309317. May we please have marked as applicant Exhibit 17 the ERD Appendix 10, which is a topographic map, filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 18, ERD Appendix 11, which is an updated glare study filed April 29th, 2024, under mail log number 309317. May we please have marked as applicant exhibit 19, ERD Appendix 12, which is the EJ screen report filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 20, ERD Appendix 13, which is the subscriber organization approval filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant exhibit 21, ERD Appendix 14, which is the water use exemption application filed April 22nd, 2024, also under mail log number 309115. May we please have marked as applicant exhibit 22, ERD Appendix 15, which is the FAA and MAA notice analysis filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 23, ERD Appendix 16, which is the vegetation management plan filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 24, ERD Appendix 17, which is the construction traffic map filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 25, ERD Appendix 18, which is the MDE non-tidal wetlands division review filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 26, ERD Appendix 19, which is the MDE Tier 2 review filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 27 and 27C, the public and confidential versions of ERD Appendix 20, which are updated JEDI results, both filed on May 16th, 2024, under mail log number 309703. May we please have marked as applicant exhibit 28, ERD Appendix 21, which is the AVERT analysis, filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 29, ERD Appendix 22, which is correspondence with Carroll County, filed April 22nd, 2024, under mail log number 309115. May we please have marked as applicant exhibit 30, the certificate of compliance, filed May 31st, 2024, under mail log number 309925. May we please have marked as applicant exhibit 31, the certificates of publication for the first public comment hearing, filed November 12th, 2024, under mail log number 313535. May we please have marked as applicant exhibit 32, the certificates of publication for the second public comment hearing, filed April 7th, 2025, under mail log number 317553. May we please have marked as applicant exhibit 33, the sign affidavit, filed on April 10th, 2025, under mail log number 317728. May we please have marked as applicant exhibit 34, the revised decommissioning plan, the clean version, filed May 27th, 2025, under mail log number 319141. And Your Honor, just a note, with your permission, when Mr. Boswell takes the stand, he would like to correct one reference that was made in the updated version of the decommissioning plan. And may we please have marked as applicant exhibit 35, the revised decommissioning plan, the red line version, filed May 27th, 2025, under mail log number 319141. May we please have marked as applicant exhibit 36, the certificates of publication for the third public comment hearing, filed June 4th, 2025, under mail log number 319378. And may we please have marked as applicant exhibit 37, the settlement status update, filed June 9th, 2025, under mail log number 319481.
Okay, applicants' exhibits 2 through 37 are marked.
And, Your Honor, I guess at this point, would you like to call the witnesses to the stand?
Did you want to attempt to move these into the record at this time, or not until?
I guess because Mr. Boswell will have one minor correction to the decommissioning plan, would we need to wait for it to move that one into
Okay,
for admission?
but you would like to move 2 through 33?
Yes, please, Your Honor, and 2 through 33, and then 36 and 37, please.
Okay, are there any objections to applicant exhibits 2 through 33, or 36 or 37?
No, Your Honor.
No objection.
Okay,
No.
applicants exhibits 2 through 33 are admitted into the record, and applicant exhibits 36 and 37 are admitted.
Thank you, Your Honor. And at this point, Your Honor, may we please call our first witness?
Please.
Your Honor, at this point, the applicant calls Mr. Ryan Boswell.
Raise your right hand. Do you solemnly affirm under the penalty of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Ryan Boswell, RyanBoswell. I'm here on behalf of the applicant. Business address 1700 Rockville Pike, Suite 305, Rockville, Maryland.
Thank you, Your Honor. Good morning, Mr. Boswell.
Good morning.
Could you please state your position with the applicant?
I'm Vice President of Development.
And Mr. Boswell, are you familiar with the project that's being proposed here?
I am.
And Mr. Boswell, did you cause to be filed direct testimony of Ryan Boswell on October 30th, 2024, under mail log number 311749?
I did.
And was that prepared by you or under your supervision?
It was.
Do you have any changes or corrections you'd like to make to that testimony?
I do not.
If I asked you the same questions appearing in that document here today, would you provide the same or substantially similar answers?
Yes, I would.
Thank you, Mr. Boswell. And did you also cause to be filed a supplemental direct testimony of Ryan Boswell on March 7th, 2025, under mail log number 316553?
I did.
And was that document prepared by you or under your supervision?
Yes, it was.
Do you have any corrections to that document?
Not today, no.
If I asked you the same questions appearing in that document here today, would you provide the same or substantially similar answers?
Yes, I would.
Thank you, Mr. Boswell. And Mr. Boswell, did you, are you also appearing on behalf of the applicant to adopt the rebuttal testimony of John Miller, filed June 16th, 2025, under mail log number 319652?
Yes, I am.
Are you familiar with that testimony?
I am.
If I asked you, or do you have any corrections you'd like to make to that testimony?
I do have one correction to make. On page 2 of Mr. Miller's rebuttal testimony, line 17, it makes reference to Miss Barrett. That should be more appropriately Mr. Barrett. I'd also, is now the time to address the decommissioning plan?
Yes, Mr. Boswell, do you have any corrections you'd like to make to the applicant's clean and red line versions of the decommissioning plan, which are being proposed as applicant exhibits 34 and 35?
I do have some corrections to make since I'm sponsoring the narrative of the plan. At the top of page 6, it refers to the county's decom requirements. The correct reference to that section of Carroll County Code of Ordinances should read 158.153, capital F, lowercase l.
Thank you, Mr. Boswell. And is that your only correction?
That is.
Okay. And finally, Mr. Boswell, are you also here to sponsor the rebuttal testimony of John Miller, filed on June 30th, 2025, under mail log number 320040.
I am.
And are you familiar with that testimony?
Yes, I am.
If I asked you the same questions appearing in that document here today, would you provide the same or substantially similar answers?
I would.
And I apologize, I forgot to ask you, do you have any corrections you'd like to make to that?
No, I don't.
Thank you, Mr. Boswell. Your Honor, I'd like to ask that applicant, as well as direct testimony, be marked as applicant Exhibit 38.
So marked.
Mr. Boswell's supplemental direct testimony be marked as applicant Exhibit 39.
So marked.
The rebuttal testimony of John Miller, as adopted by Mr. Boswell, be marked as applicant Exhibit 40.
So marked.
And may we please have the rebuttal testimony of John Miller, as adopted by Mr. Boswell, marked as applicant Exhibit 41.
So marked.
And, Your Honor, I'd respectfully ask that applicant Exhibits 34 and 35, which were the clean and redline versions of the decommissioning plan, as just corrected by Mr. Boswell, and then applicant Exhibits 38, 39, 40, and 41 be admitted into the record subject to cross-examination.
Any objections?
No objections.
No objection.
No objections.
Okay, applicant exhibits 34 and 35 are admitted, and applicants exhibits 38, 39, 40, and 41 are admitted into the record.
Thank you, Your Honor. At this point, Mr. Boswell is available for cross-examination.
Mr. Towson.
No cross-examination, Your Honor.
Mr. Meehan.
No cross, thank you.
Do you have applicant exhibit 16 in front of you? That's the concept site plan. You don't have anything larger than 8.5 by 11?
Unfortunately, I left it in the car, Your Honor.
So page 4 of 7 of the concept site plan, starting with page 4, the project is shown with the panels on the site. And I just wanted to ask you a few questions if you're familiar with it, but I don't know, since you don't.
Your Honor, I believe, if I may, I believe there was an updated version of the conceptual site plan submitted with Mr. Boswell's supplemental direct testimony, and I believe that's probably the most recent version. It was included as an attachment. I believe that would have been applicant exhibit.
His supplemental direct was 39.
39.
I'm not sure it's going to matter for purposes of my question.
Oh, okay.
Do you have what you want to look at?
I do it
Okay.
small scale, but I think I can read it.
Okay, my understanding is that this project is approximately 7,634 PV modules installed as fixed tilt arrays.
That is correct.
Okay, can you go over what that means?
Yes, so in total, the project is 4.73 megawatts DC, which is the sum of the nominal capacity of each module times the count of the modules, the 7,634 modules that you mentioned. The mounting system is a fixed tilt array, meaning as opposed to single axis tracking where it rotates along a north-south axis, it's on a fixed tilt at 25 degrees and oriented towards the southern exposure.
Okay, so in your concept site plan, the north arrow is pointing up, right?
Correct.
So the panels, you said they're oriented in a fixed tilt toward the south.
That is correct.
So if one were standing along Fanny Dorsey Road to the south, they would see the face of the panels. Is that correct?
That is correct.
And how high are the panels at their highest point?
At the highest point, the vast majority of the panels are less than 12 feet, approximately 11 feet.
What do you mean vast majority?
There is a analysis that examines how that maximum height varies with the topography because the topography is not consistent across the entire LOD. I think something like 99% of the panels are 11.2 feet or less.
I recall reading that they're 15 feet in height.
The response that we submitted identifying the 15-foot height limitation is not to suggest that the way the panels are designed that they would reach 15 feet, but because there may be variations in the grading plan that could alter the height of the panels, we reference the 15-foot limit because that is consistent with Carroll County's Code of Ordinances as a maximum height. So I believe the response says that they will not exceed 15 feet.
Do you know how high the structures are themselves?
The racking system.
Yeah.
So the average middle height of the rack that the panels are mounted on is about 8 feet.
And then the panels themselves?
Because the panels are at a 25-degree angle and they're roughly 7 feet in length, it's about 3.5 additional feet on top of that 8 feet of racking. So that's how we arrive at roughly 11, slightly less than 11.5 feet.
Did you sponsor the ERD? I'm at page 5. I guess it's still the executive summary. Did you sponsor the executive summary?
I did.
Okay, so on page 5, the third paragraph.
Okay, I'm there, Your Honor.
Okay, so you're talking about setbacks in that paragraph.
Yes, I see the paragraph.
You say Project Sunshine will observe a 100-foot front setback to the property line. What does that mean, front setback?
At the time that the ERD was drafted, that reference was from the public right-of-way to the first panel.
So the south side or?
Correct. Fanny Dorsey Road being the public right-of-way there, considered the front of the lot.
Your setbacks have changed?
Yeah,
since-
that is correct, Your Honor. In the updated concept site plan, that setback has increased to 150 feet.
And you're measuring 150 feet from where to where exactly?
From the edge of the public right-of-way on Fanny Dorsey Road to the nearest panel.
So did you review the PAR?
I did, Your Honor.
The PAR at page 3, figure 1.
Bear with me. I'm sorry, you said page 3, figure 1?
Yes.
Is that right? Okay, I see the figure.
Okay, so there is a dimension there of 130 feet. Appears to be from the right-of-way, perhaps, of Fanny Dorsey Road to perhaps the first panel. Do you see that? It's pretty small.
I do see that, Your Honor, but that is measuring from the public right-of-way to the fence, and there's an additional 20-foot setback between the fence and the first panel.
Okay, I didn't know if you were telling me that the plan had changed since the PAR was filed, but that's, you said it's from the right-of-way to the fence.
Yeah, I do see that it's a bit unclear, but it is measuring from the right-of-way to the fence.
At the end of that same paragraph, I'm sorry, I'm back to your ERD, your executive summary. You're talking about the landscape buffer, which I know that you increased from 25 feet to 35 feet, correct?
That is correct.
But you go on to say that these setbacks, combined with the existing vegetation and low operating decibel level of the facility's inverters, will make the ambient noise indistinguishable from background noise. This ensures there will be no change to the rural soundscape of the neighbors, and the facility is capable of being visually screened. Can you tell me what you mean when you say that the facility is capable of being visually screened?
We believe that with the landscape buffer that is proposed, that the view shed will be interrupted, if not entirely opaque, between Fanny Dorsey Road and the array itself.
Do you have anything that reflects that? Did you do a rendering of any sort?
I don't believe we have a rendering, Your Honor.
So on what do you base that opinion?
The Carroll County Code requires that those landscaping trees be planted at 12 feet in height. Our fence is 7 feet tall. The panels are approximately 12 feet, or slightly less than 12 feet, as I earlier stated, about 11 feet. So we believe that the density of the plantings and the height of those plantings will effectively screen the view.
But that doesn't take into account, what you just said doesn't take into account topography, correct?
That is correct. Panels at the northern end of the field are at a slightly higher elevation than at the southern end of the field. So the intent is not to completely block the view of the panels, but to screen them, rather.
So they'll still be visible.
I do believe some of the residences to the south on Fanny Dorsey Road are at an elevation that will make it possible to see the panels even after planting the landscape.
But again, Chaberton didn't conduct a visibility analysis, correct?
I'm not aware of one, no.
Did you review PPRP's visibility analysis?
I did.
Do you concur with PPRP's visibility analysis?
To the best of my ability, but it's not an area of expertise for me.
I'm sorry, I didn't hear that.
I said to the best of my ability, I concur with their analysis, but it's not an area of expertise for me.
Do you still have the PAR in front of you?
Yes.
So I just wanted to go over figures 4, 5, and 6, which are the visibility analysis that PPRP performed year 0, year 3, and year 5.
I see those figures, Your Honor.
You don't have a color copy? Oh, you do, good, okay. So, even though it's not your area of expertise, when I look at this, I take it to mean that the blue portion, which PPRP has labeled as visibility analysis year, well, I'm on year 3, I'm sorry, this figure 5. The blue portions are where you could see some portion of the facility, correct?
That seems to be what it's indicating, yes.
So the properties to the southwest and the south and the southeast can all see the facility in year 3, correct?
In year 3, it does look like there is some limited visibility from those properties.
Why do you say limited?
By comparison to the year zero, it does appear to be fairly consistent. I should say that I guess by year 5 that visibility has been reduced according to figure 6.
So now in figure 6, it's a lighter blue color, correct?
Both a lighter blue color and there seems to be less intensity of that visibility field.
When you say less intensity, what do you mean?
The areas of blue, darker blue in figure 3 or in year 3, figure 5, they seem to be reduced in size compared to, in year 5 in the light blue, the areas of visibility appear to be reduced in size compared to year 3. For those
Okay,
properties.
so less visibility, but you said intensity. I didn't know if you meant something else besides size.
No, I don't mean anything except visibility.
I'm still on figure 6, which is year 5. So if you look at the houses along Jasana Court, it would indicate to me that the first 2, the project would be visible to those properties, correct? Those houses, residential dwellings?
That does look to be the case, yes, even in year 5.
And I don't know, if you travel up Jasana Court, there's a building, I'm not sure what it is. I don't know if you know, the one that's kind of surrounded in blue. Do you see that? The farthest
Yes,
west.
I believe, well, I don't have enough resolution on this image to know for sure. That may be an outbuilding for the participating landowner's property.
Your Honor, if it'd be helpful, I have a larger conceptual site plan that Mr. Boswell may be able to.
He might appreciate that, yes.
Looking at the conceptual site plan, Your Honor, it does appear that that structure is part of the owner's property, the participating owner.
The one that is behind a house on Jasana Court? Are we talking about the same property?
Yeah, Your Honor, the one I'm referring to is adjacent to Lou and Patricia Toth's property, their residential property is separate from the property where the facility is being proposed, but that large structure that has some visibility is a barn related to their broader property use.
And then as we travel, I guess, northwest along Fanny Dorsey Road, again, still on figure 6, which is year 5, there's blue as in visibility to the properties along Fanny Dorsey Road, correct?
Correct.
And then also to some properties along Shenandoah Drive, correct?
That is correct.
Is Chaberton requesting that any Carroll County zoning ordinances be preempted as part of this CPCN?
Not explicitly, Your Honor, no.
What do you mean, not explicitly?
There are some provisions of the code that require 400-foot setbacks, but it also allows for the Planning Commission to modify that setback to 100 feet. So we think that given those conditions and with the passage of the Renewable Energy Certainty Act, that we don't require preemption.
Are you talking about what's now Public Utilities Article 7-218?
Yes, I am.
And your position is that that statute applies to this project now?
I don't believe that Carroll County has yet adopted zoning that is consistent with that statute. but we believe that our plan is consistent with their zoning ordinance that was updated in December of 2024.
Your plan is consistent with the Carroll County zoning ordinance that was updated in December of 2024, with the exception of the 400-foot setbacks?
That is correct, Your Honor. But as I mentioned, the Planning Commission could modify that setback.
Okay, what about 7-218?
Yes, Your Honor, we believe the project is consistent with 7-218.
Is there any requirements, are there any requirements in 7-218 with which the project does not conform?
No, Your Honor, I don't believe so.
What does, if you know, what does 7-218 provide for a fence?
One moment while I review it. Uh, 7-218 in F, F2 Roman numeral 3 seems to address fencing. Says a project shall provide non-barbed wire fencing only on the interior of a landscape buffer or immediately adjacent to solar energy generation station that is not more than 20 feet in height, that is only black or green vinyl wire mesh if the owner proposes to use chain link fencing, and that is not less than 50 feet away from the edge of any public right-of-way. Project may also use barbed wire fencing around the substations or other critical infrastructure for protection of that infrastructure.
Okay, can you talk about your plan in relation to what you just read?
Sure. Our plan does propose a fence interior to the landscape buffer. It's not more than 20 feet in height. We are not proposing to use a chain link fence, and so therefore it does not meet that requirement, but the section doesn't appear to me to strictly limit the fencing material to chain link. But our fence is also not less than 50 feet away from the edge of the public road right-of-way, and we're not proposing any barbed wire fencing around substations or critical infrastructure.
Okay. If I had any questions about glare, that's for witness Barrett, is that correct?
Yes, Your Honor.
Any redirect?
Excuse me, just one or two clarification questions. Mr. Boswell, do you remember when Chief Judge Lawrence was asking you about potential preemption of county zoning requirements?
I do.
What is the zoning designation of the land on which this parcel is proposed?
It's zoned agricultural.
And under the version of the Carroll County Code that was adopted last December, would this project be permitted in land that's zoned agriculturally?
No, it would not. So I should clarify my earlier statements that we would ask that the commission exercise its preemptive authority to allow for the siting of this project on agricultural land.
Thank you. And Mr. Boswell, if the county were to determine that it could not modify that, the county's setback requirement of 400 feet, would the applicant have a request for the commission in that regard?
In that case, we would ask that the commission preempt the setback requirement to 150 feet from the front and 100 feet from the sides of the property, which we believe is consistent with Public Utilities Article 7-218.
And Mr. Boswell, speaking about Public Utilities Article 7-218, can you tell me when, do you remember roughly when this application was filed?
Let me review that date.
Would you agree with April 2024?
Yes, I would.
And is it the applicant's position that the requirements of Public Utilities Article 7-218 are directly applicable to this project?
It's our position that the project has been grandfathered from those requirements because the CPCN application was filed prior to July 1st of 2025.
And but when you were discussing before, what is the applicant's position about if those requirements were applicable to this project, whether the project would meet those requirements?
If the requirements were applicable to this project, we would conform with those requirements.
Thank you. Those are all the questions I have, Your Honor.
Would conform, or you already do conform?
To the best of my knowledge, we already conform.
Any other questions based on my questions?
No, Your Honor.
Just a few, Your Honor. Mr. Possible, do you recall when Chief Judge Lawrence was asking you about the fencing requirements under 7-218?
Yes, I do.
In Mr. Miller's rebuttal testimony, he talks about fencing at the very end of his testimony, bottom page 2, top of page 3. He's proposing an opaque fence. Is that the applicant's position, that they're going to provide an opaque fence?
We would provide an opaque fence, at least along the southwestern sides and the eastern side of the array. Along the northern side of the array, we don't believe that's necessary because there's dense forest cover and few residences.
And how high would that fence be?
It would be at least 7 feet tall.
That's all I have.
Staff?
No, thank you.
Thank you, Mr. Boswell.
Thank you.
Your Honor, for the applicant's next, may I call the next witness, please,
Please.
Your Honor? Your Honor, the applicant calls Mr. Charles Walker.
Raise your right hand. Do you solemnly affirm under penalty of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Yes, it's Charles Walker, Charles, Walker. My business address is 9175 Guilford Road, Suite 310, Columbia, Maryland, 21046.
Thank you.
Good morning, Mr. Walker.
Good morning.
Could you please state your position of employment, please?
Yes, I'm a project manager at Arm Group LLC.
And did you cause to be filed the direct testimony of Charles Walker on March 7th, 2025, under mail log number 316553?
I did.
And was that testimony prepared by you or under your supervision?
Yes,
Do you have any corrections you'd like to make to that testimony?
I do not.
If I asked you the same questions appearing in that document, would you provide the same or substantially similar questions today?
I would.
Thank you, Mr. Walker. And, Your Honor, I'd like to ask that the direct testimony of Charles Walker, filed on March 7th, 2025, under mail log number 316553, be marked as applicant exhibit 42 and admitted into the record, subject to cross-examination.
It's marked as 42. Any objections to 42?
No objections.
No objections.
None from staff, thank you.
Applicant Exhibit 42 is admitted.
Thank you, Your Honor. And at this point, Mr. Walker is available for cross-examination.
No cross from PPRP.
No cross from the county.
No cross from staff.
I don't have any questions for you, Mr. Walker. Thank you.
Thank you.
Your Honor, may we call our next witness, please?
Please.
Thank you. Your Honor, at this point, the applicant calls Mr. Patrick Gesselman.
Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
Yeah, it's Patrick Gesselman. That's Patrick. Gesselman is Gessleman. My business address is 1700 Rockville Pike in Rockville, Maryland.
Thank you.
Good morning, Mr. Gesselman.
Good morning.
Can you please state your position of employment?
Director of Engineering at Chaberton Energy.
And are you familiar with this project?
Yes, sir.
And did you cause to be filed the rebuttal testimony of Patrick Gesselman on June 16th, 2025, under mail log number 319652?
Yes, sir.
And are you also, as part of that rebuttal testimony, are you adopting the direct testimony of Piero Melitz, filed October 30th, 2024, under mail log number 311749?
Yes, sir. That's correct.
And if I asked you the same questions appearing in those documents here today, would you provide the same or substantially similar answers?
Yes, sir. I would.
Do you have any corrections you'd like to make to either of those documents?
No, sir. I do not.
Thank you. Your Honor, we'd like to ask that the direct testimony of Piero Melitz, filed October 30th, 2024, under mail log number 311749, and the rebuttal testimony of Patrick Gesselman, filed on June 16th, 2025, under mail log number 319652, be marked as applicant exhibits 43 and 44, respectively, and be admitted into the record subject to cross-examination.
They're marked as applicant exhibit 43 and 44. Any objections?
No objections.
No objections.
None from staff.
Applicant exhibits 43 and 44 are admitted.
Thank you, Your Honor. And Mr. Gesselman is available for cross-examination.
No cross from PPRP.
No cross from the county.
No cross from staff.
Thank you.
Thank you so much.
And, Your Honor, may we call our last witness now?
Yes.
Thank you. Your Honor, at this point, we'd like to call Mr. Stephen Barrett.
Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name, spell your first and last name, and give us your business address.
Sure, it's Stephen, Stephen, Barrett, B as in boy, ARRETT, and my business address is 10 River Run, Williamstown, Massachusetts.
Thank you.
You can sit down, please.
Good morning, Mr. Barrett.
Good morning.
And can you please state your position of employment?
Sure, I own my own company, Barrett Energy Resources Group, one-man shop.
And are you familiar with this project?
I'm very familiar with it.
And did you cause to be filed on June 30th, 2025, the surrebuttal testimony of Stephen Barrett under mail log number 320040?
Yes, I did.
And was that document prepared by you or under your supervision?
Yes, it was.
Do you have any corrections you'd like to make to that document?
No corrections.
If I asked you the same questions appearing in that document here today, would you provide the same or substantially similar answers?
Yes, I would.
Your Honor, we'd like to ask that the surrebuttal testimony of Stephen Barrett, filed June 30th, 2025, under mail log number 320040, be marked as applicant exhibit 45 and admitted into the record subject to cross-examination.
It's marked as applicant exhibit 45. Any objections?
No objections.
No objections.
None from staff.
Okay, applicant exhibit 45 is admitted.
Thank you, Your Honor. Mr. Barrett is available for cross-examination.
No cross from PPRP.
No cross from the county.
No cross from staff.
Mr. Barrett, you disagree with PPRP's glare analysis, correct?
Well, I think the glare analysis can vary based on assumptions. So there are a few assumptions that I would would recommend would be different. But otherwise, I replicated their analysis. They did an excellent job. And in general, I think it was the appropriate analysis, but I do disagree with a few of the assumptions.
Can you tell me about those assumptions?
The most critical assumption is the height of the panels. The PPRP used a height of 15 feet, which I believe was the worst case maximum height of the panels. I guess as Mr. Boswell said this morning, the actual height is around 11 or 12 feet max.
What did you use?
I used 6.5 feet, which is the centroid of the panels, and the developer of the forged solar model recommends that you use the centroid.
Why?
Because glare is caused by a large regular surface, whether it be a lake, a body of water, or a building. It's not caused by individual smaller areas. So if you take the 15-foot height, you would only be using the very top, narrow, thin surfaces of each of those rows. Whereas if you take the centroid or even lower, then you are able to capture a much more consistent large surface of solar panels.
Any other assumptions that yours were different than PPRP's?
My initial assumptions for the observer heights were slightly different. For the observer height, I used 5 feet. For a person standing on a property, PPRP used 9 feet. I've seen a lot of different heights used, but I think the 9-foot is appropriate, as well as used for motor vehicles 4 feet, and they recommended 5.5 feet, which again I think is reasonable, and I use those in my updated analysis.
Do you know the height of the residential buildings across Fanny Dorsey Road from the project?
I don't know the exact height of those buildings.
Do you know if they're 1-story or 2-story?
I think many of them are 2-story.
Any other assumptions?
No other assumptions, no.
Any redirect?
Thank you. Sorry. No, thank you, Your Honor.
Any questions based on my questions?
No, Your Honor.
Mr. Meehan? Take your time.
Just one. Your assumption on the observer height. You said you used the average you used was 5 feet.
Yeah, in my initial analysis, but then when I replicated PPRP's model runs, I used 9 feet.
And you felt that the results were consistent?
Yes, I mean, as I presented in my testimony, there were a couple of things that varied in the results. I showed that only 2 of the receptors, 2 of the 6 that they showed yellow glare, only 2 in my analysis showed yellow glare. I spent time poring over all the assumptions, the latitude and longitude of every receptor, as well as the same for the solar panels, and I could find no reason why they'd be different. The only thing that I can think of is that the modeler is constantly updating the model to try and refine it, and their analysis was done, I believe, in April, and mine was done in June, and so that may be some of the reasons why it was a little bit different. The other thing that I did was I extended, it seemed like the majority of the glare was coming from the southern part of the array, where there was kind of a break in the landscape screening for the access road. And when you extend the landscape screening further, it eliminates some of that glare.
But you would agree that your conclusions and the PPRP's conclusions of its analysis conclusion are pretty different.
Mine showed less glare.
Right. That's all I have, Your Honor.
And I'm sorry, the main reason was based on the height of the panels.
Just explain that again for me. I'm not very, I don't really understand. So you're saying that the height you used was 6 feet?
6.5.
6.5.
And that was calculated based on the bottom of the panel being 2 feet above the ground level and the top being 15 feet. So I used the centroid, which is what is recommended by the modeler.
And as you understand it, PPRP's analysis used the top edge.
That's correct.
And what makes the difference?
Well, the height is important for all of the receptors for the landscaping because it's the model geometrically analyzes where the sun is, where the surface of the panels are, where there are obstructions, and where the receptors are. So each of those numbers, there should be some agreement on that because if they vary, the results can vary.
That's all I have.
No questions for staff, from staff.
Thank you.
Your Honor, that, excuse me, that concludes the applicant's witnesses and exhibits.
Mr. Towson.
Your Honor, I apologize. Before we have another witness, may I go and grab those binders, please?
Sure. Yes.
Morning, Your Honor. PPRP has 7 pre-filed exhibits we'd like to mark for identification this morning. All 7 exhibits were filed on June 4th, 2025. All 7 were filed under mail log number 319371. PPRP Exhibit 1 for identification is the direct testimony of Christopher Adland. PPRP Exhibit 2 is a secretarial letter signed by the Secretaries of the Maryland Department of Natural Resources and the Maryland Department of the Environment. PPRP Exhibit 3 for identification is initial recommended license conditions. PPRP Exhibit 4 is the project assessment report. PPRP Exhibit 5 is Appendix A to the project assessment report, and that consists of selected responses to PPRP data requests. PPRP Exhibit 6 is Appendix B to the project assessment report, and that is the glare analysis. And finally, PPRP Exhibit 7 for identification is Appendix C to the project assessment report, which consists of reference sections of PPRP's website. At this time, I would like to move for the admission of PPRP Exhibits 2 through 7 into the record.
Okay, PPRP Exhibits 2 through 7 are marked. Any objections?
No, Your Honor.
No, Your Honor.
None from staff.
Okay, PPRP Exhibits 2, 3, 4, 5, 6, and 7 are admitted into the record.
And at this time, we call Mr. Christopher Adland to the stand.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
I do.
Please state your name, spell your first and last name, and give us your business address.
My name is Christopher Adlin. That's C-H-R-I-S-T-O-P-H-E-R. Adland, A-A-D-L-A-N-D. My business address is Maryland Front Natural Resources at 580 Taylor Avenue, Annapolis, Maryland 21401.
Thank you.
Mr. Adland, do you have in front of you what's been marked as PPRP Exhibit 1 for identification, which is the direct testimony, that was filed on June 4th, 2025?
I do.
Did you prepare this testimony, or was it prepared under your supervision?
Yes, it was.
Is it true and accurate to the best of your knowledge?
Yes.
If you were answering those questions today under oath, would your answers be the same or substantially the same?
Yes.
Do you have any corrections or amendments you would like to make to that testimony?
No.
Your Honor, at this time, I'd like to move for admission of PPRP Exhibit 1 into the record, and I would tender the witness for examination.
Any objections?
No objections, Your Honor.
Mr. Meehan, do you object to this testimony?
I do not object.
None.
PPRP Exhibit 1 will be admitted. If you can just make sure that mic, yeah, you move it closer to you maybe. There we go. Thank you.
He's tendered for examination, Your Honor.
Do you have any questions for this witness?
No, thank you, Your Honor.
Yes, Your Honor. Mr. Adlin, you heard Mr. Barrett's testimony on the glare analysis?
I did.
And what's your opinion? Do you agree with the analysis that the applicant has submitted in its rebuttal testimony?
Yes, I'd like to point out the differences between PPRP's independent analysis and the previous witnesses.
Please do.
First of all, I'd like to say typically when PPRP does one of these independent analysis, we do a worst-case scenario of our analysis. It differs from the applicant's analysis in that PPRP's analysis does not include off-property vegetative buffers such as existing tree lines or neighboring properties, which correspond to the applicant's response to PPRP's data request number 5-5. In other words, we only utilize buffers, trees, that kind of thing that's within the applicant's control. So it's as if the residences surrounding the property have zero obstructions to the panels. Now, the applicant used existing buffers outside the applicant's property in their analysis.
And what is that? So what's the
Well,
difference?
the result is that that the applicant did accurately show there's going to be less glare because they included existing buffers on neighboring properties, which we did not use in our analysis. Because essentially, the applicant does not have control over those buffers, outside their property line. If, one of the neighbors decide to cut down their trees, for example, they would obviously receive more glare. And that's what our analysis is trying to show. It's a worst-case scenario. The other difference is the applicant's analysis models a project as one array. PPRP models the project is two arrays because of the elevation differences across the project site. So, if if the panels are modeled at varying heights with an array, the model will planarize the array, essentially smoothing out the elevation difference onto one plane. So we have a more accurate representation of the elevation differences, whereas the applicant's analysis, at least the original analysis, basically flattened out the array. So it didn't give a super accurate difference in elevation. And as the previous witness said, they utilized different receptor heights. PPRP's analysis used 5.5 feet for route receptors, a stationary receptor height, and a stationary receptor height of 9 feet. PPRP's route receptors modeled by the approximate height of a person driving a vehicle, and the stationary height represents a person's view from a second story of a home. There's two other differences. Number one, we were able to, when talking about in our analysis, there was a 40-foot elevation difference in some of the panel arrays locations that we analyzed versus the applicants, which would give a different result. And the other thing that we did differently was, it is true that the forged solar tool does represent taking sort of an average height of the panel, as the previous applicant said. But under the documentation, it says for more accuracy, the user should perform analysis using minimum, maximum values of the vertex heights based on the PV panel dimensions. This would, doing so will expand the range of observed solar glare when compared to results using single height value. So by us doing the minimum, maximum, we felt that we got a slightly more accurate result for glare than taking the average height of the panel.
So you stand by your analysis?
Yes, we do.
Okay. In fact, on page 25 of your direct testimony, on lines 3 and 4, you say PPRP believes the commission should rely on its, meaning PPRP's, independent glare and visibility analyses in this case.
We feel it's the more accurate analysis.
Okay. On the visibility side of things, I mean, sort of, why don't you opine on that a little bit?
Well, I mean, it is true that years 0 through 3, there's going to be larger visibility. One of the things that we showed in our PAR, you have to realize that analysis again is not taking into account any of the buffering on properties outside the applicant's control. So the visibility would be less if we did, but we don't feel it's correct to include those buffers that the applicant has no control over in the analysis. We feel that by year 5, once the buffers have matured, most of the visibility is going to be mitigated, except for a few of the houses directly across on the southern side of Fannie Dorsey Road. Just due to the elevations, they're still going to have a visibility above the buffer at year 5 and be able to see some of the panels.
So those poor people at the end of the road, they're going to be stuck with seeing this.
Well, so we do have a complaint resolution, recommended license condition, and we call out specifically that the applicant work with the 3 residents that we call out in a recommended license conditions, that if they have any complaints, that they work with that. I'm sorry about that. Work with those residents to try to come with a resolution. So, for example, they could plant buffers on those residents' properties that would help block that view.
Is that a typical approach? You sort of build it and then solve the problem rather than solve the problem first?
Well, what PPRP does is try to work with the applicant to mitigate to the maximum extent practical any visual impacts, but it's almost impossible to hide many of these projects. So we typically, in other cases, if there was visual impacts that could not be mitigated, it happens very common, like on Western Maryland, where panels are built on the side of mountains. We have a complete resolution license condition that requires the applicant to work with any property owners that have a complaint.
Okay, and then finally back to the glare issue.
Mm-hmm.
Mr. Barrett testified that the height of the panel, the height they used was 6.5 feet. Sorry, 6.5 feet.
Mm-hmm.
And I believe the PPRP analysis was 12 feet.
Right.
Why is that? What's the benefit of using the 12-foot versus the 6.5 or some other number?
That would have been the maximum allowable height, and because the heights are actually going to vary depending on where you are in the array, we just took a maximum minimum.
I hate to interrupt, but I thought it was 15 feet. I don't want the record to be muddied. I thought.
I think
I think you're right.
I think you're correct. Yeah, it was 15 feet. So we took, again, this is worst case scenario that we typically model. So we took a worst case maximum minimum, and that's what our analysis shows.
In fact, and I'm not very bright at this, but if you took a 6.5 foot, that's sort of stuck in the middle. But the reality is, the glare is going to come from the top of the panel, correct? Or am I wrong?
Depending on where you're looking from, that could be correct, you know.
That's all I have, Your Honor. Thank you very much. Thank you, sir.
No questions, thank you.
Any redirect?
No redirect, Your Honor.
Do you have the PAR in front of you?
I do.
So you said by year 5, which is figure 6,
Mm-hmm.
PPRP feels as though the visibility is mitigated to the extent that it can be, except for, you said, houses along Fanny Dorsey Road to the south.
For the most part, yes.
Okay, so can you, in figure 6, point me to which properties you're talking about?
They would be, I believe, if you're heading up Fanny Dorsey Road to the northwest before it hits the curve, it's the first 3 residents that you come across towards the upper end of the applicant's LOD.
So closer to,
Closer to where it starts to curve at the.
okay.
If you see that.
Well, I see Sacramento Court, so closer to Sacramento Court,
My
and then it's Shenandoah Drive.
let me
It's a
see.
semicircle.
Mine's so small that I have trouble reading. But yeah, essentially it's where you see the if you see where the project, there's like a curve on the western side and it comes down to Fanny Dorsey Road. There's 3 residences right there well, they're basically on the southern side. I'd have to have a detailed map to show you where those
Okay,
3
but there's
residences
blue along Fanny Dorsey Road as you continue southeast, is there not?
are. There is.
Okay, so what's the difference between those 3 parcels you're concerned about? And
Well, in part, this isn't, this analysis does not take into account any of the existing vegetative screenings that's on the private properties. So it's going to be greater than the reality. Now, it's worst case scenario. If those neighbors cut all their shrubs, trees down, this would be the map, the visibility map.
okay, but why do you know to not be concerned about the properties farther southeast? The way you
yeah,
are about the properties closer to the curve in the project?
just due to the analysis, those are the 3 that are going to be the greatest affected. And it's due to elevation differences and stuff. Like I said, the portion of the site has a higher elevation than the rest, and so they'll be able to see, and they will also receive more glare. Those 3 residences
Okay,
than
but
any of the other sites.
what you said about visibility, I can't tell from this figure, correct?
I would say that's accurate. This is, again, it's a model, worst case scenario. Every other opaque structure or buffer is not included in that model.
And then figures 8, 9, and 10, I believe you overlaid the visibility and glare analysis.
Right. Mm-hmm. And so figure 10 illustrates in yellow where the remaining glare would be in the residences that are greatest affected, mainly because of the height of those residences and the elevation of those residences.
Yeah, you indicated that you modeled the glare based on a receptor height of 9 feet.
Correct.
And I believe you said that was because the view from someone in a second-story house?
Yeah, that's the way we model that. Yeah.
But a second-story house is, the window in a second-story house is more than 9 feet off the ground, isn't it?
That's just a height that they typically pick to run the analysis. It's just kind of a standard height that PPRP uses. I didn't run the analysis. I'm not an expert on why that's a standard height they typically pick, but that's typically what we use in all our analysis, independent analysis.
So if you look at year 5, figure 10, can you locate OP 13 and OP 14?
Yes. Mm-hmm.
Can you tell me why, again, it's your chart, blue is visibility year 5.
Right.
Why is there visibility on the other side of OP 13 of the facility from the house? In other words, the house is between that patch of, that little spot of blue and the facility, and I'm wondering
It's
why.
going to be just due to elevation. They'll be able to see the panels.
From in front of the house?
Yeah, the receptors typically put at a spot in front of the residence.
And doesn't take into account the fact that there's a residence there.
Well, we only put the receptors typically in front of an existing residence. Does that make sense? Because we're trying to model the impact on individual residences.
So is the blue that I see next to OP 13, does that really represent what a person in that house would? Does that tell me that a person in that house would see it, as opposed to you can see it from the front yard? Because that's what it looks like in the figure.
At this scale, it's very difficult to tell exactly where that marker was put. In front of the house, typically,
You'd put it in front of the house even if the facility is behind the house?
We'd put on the front facing the facility.
Okay, so what you think is that the scale of this isn't terribly accurate, and that blue
Exactly.
little piece
It's really
is
hard
actually,
to tell at this scale where those markers are exactly placed. But
that's actually that residence 9 feet high on that residence.
yeah, well, there's going to be 2. Yeah, 9 foot, and I think also 5.5 feet.
5.5 is the car, isn't it?
Car and the height of a second-story building. Yeah, that's the way they typically model it. Because we also include driveways. So some of the markers are placed on driveways leading up to a residence as well. So
You were the witness in case number 9746, Elk Development, correct?
correct.
Do you recall that in that case, your conclusion that there would be green glare only for residences?
I believe so.
But in this case, there will still be yellow glare for some properties, correct?
That's correct.
Do you have the license conditions in front of you?
I do.
You, in response to Mr. Meehan's question, you said that something about that those particular properties that PPRP is concerned about are called out specifically.
That's true.
Where can I find that?
It is. I'll give you the exact. Page 8, predicted glare mitigation number 28. It's the first time it's called out under predicted glare mitigation. So the project owner shall identify and list each residential property that potentially could be impacted by amount of yellow glare from the project and shall consult.
I'm sorry, where are you? And I'm on 27. Oh, predicted glare mitigation 28, okay.
Yes, yeah. So project shall consult directly with the owners of each identified property to discuss potential for glare impacts and mitigation approaches. At a minimum, a list of identified residential properties should include and we list the 3 residences that we predict would have the largest amount of glare. And that's in response to public comments.
Does PPRP know if there is potential mitigation that would be successful with respect to those properties?
I mean, that's between the applicant and those property owners. I mean, in past cases, if additional screening or plantings are put in the residence yards, that could definitely wholly or partially mitigate, the glare or visibility of the project site.
But
that's an example.
PPRP doesn't know for certain.
We don't. We leave it up to the applicant and to negotiate with if there's a complaint with the residents. In some cases, applicants have purchased blackout curtains. There's many different ways to mitigate glare, but we don't make those determinations.
So license condition recommended by PPRP, number 7, complaint resolution.
Mm-hmm.
What does PPRP envision happening under this proposed condition?
Well, essentially, if there's a complaint, the applicant needs to file the complaint with the PSC, and we envision that they work with the applicant, and if no resolution is found, then it would be up to the PSC to help negotiate a resolution to the complaint.
But it would be in the nature of what you already spoke of, vegetative buffer on the person's property or blackout curtains, that type of thing.
Yeah, I mean, there may be another option. There could be a fence, or it could be, there's many ways to kind of mitigate it, but we don't specify that. We allow the applicant to.
But when PPRP uses the phrase, the aggrieved party may seek relief by filing a complaint with the PSC, PPRP is intending for that complaint to involve what mitigation can be done. That's the
correct.
relief that you're referring to.
That's correct.
Do you know how wide the existing buffer to the north is?
I don't have that figure with me, but it's pretty extensive. I don't have the exact width of the northern buffer, but it's heavily forested.
And as far as the glare along Fanny Dorsey Road for drivers, motorists, can you address that? That remains, right? That can't be mitigated.
Yes, there will be some, and it's typically seasonal, about 2 months out of the year, for much of that glare.
Do you know which 2 months?
Let's see if I can find that. I thought I had that here.
I have year zero is on page 21 of your testimony. And then you have the reduction, but I don't know that you have the hours listed.
I have the hours. I don't have the exact months. I want to be accurate with that. I'd have to provide that in a bench DR.
Where do you have the hours?
Let's see. Well, on page 21 in my testimony, down at the bottom, we have year zero results indicate Fanny Dorsey Road, Shenandoah Drive, and one private right-of-way would receive up to 22 hours, 86 hours, and 15 hours. And then it so it has said by year 5 of operation, predicted yellow glare is reduced by 71% for Fanny Dorsey Road and 88% for OP17, which is one of the residences. By year 5, the yellow glare would be greatly reduced.
Okay, so I would have to do the math to take.
I could get that. We have that
I can
in the modeling.
reduce by
results.
71% for Fanny Dorsey Road, so I take 22 hours and I reduce that by 71%. Is that what you're saying?
Yes.
Okay, and you said that it's a couple months of the year, but how many minutes a day during those months? Do you know?
I would have to. I don't have that without. I have the modeling results. It's like 300 pages of results that I can, for each receptor, I could actually pull those numbers for you in a bench DR.
Okay.
And list all that.
Did you make a note of that?
Okay. So we could provide that for year 0, 3, and 5. How many minutes?
And during which months?
In which months? That's correct.
Okay. Okay, any questions based on my questions?
Just one very quickly, Your Honor, just for clarification, Mr. Adlin. When you were talking about just with Chief Judge Lawrence about the potential glare along Fanny Dorsey Road, in the very year 0, year 3, year 5, and so forth, based on the analysis that PPRP did that analysis include the applicant's additional suggested buffer along Fanny Dorsey Road, the extended landscaping buffer on Fanny Dorsey Road to try to close up that?
I don't believe it did.
Okay, thank you. No more questions, Your Honor.
I have some few questions. May I, Your Honor?
Yeah, I just wanted to clarify before you
Okay,
go.
sorry.
No, it's fine. There's a diagram of the reduction in glare based on what he just talked about. I saw it. It's attached to someone's testimony. Mr.
Your Honor, I believe that in Mr. Miller's
Rebuttal?
rebuttal, I believe.
Do you know what he's talking? Have you seen that? Have you seen Mr. Miller's rebuttal?
I have. I believe I might. Yes, I have.
So PPRP didn't run any sort of analysis after this.
That's correct.
Sorry, let me finish.
Oh,
the extended landscaping recommendation was proposed. PPRP didn't do anything further.
We did not.
Okay. I'm sorry. Now go ahead.
Thank you. What are blackout curtains?
They just will, allow, block out all light in entering a room.
Okay.
They're just curtains that allow to block out light.
So all these mitigation measures would be taken on the property owner's property, not like the fence or the new plantings and the blackout curtains.
Well, I think PPRP stance is that, they have they have adequately mitigated to the maximum extent practical on their property at this point. There may be other solutions, like I said. I'm not aware of every possible solution there is, but that's PPRP's stance.
What about, I mean, sounds like these are pretty egregious impacts. What about relocating the property more north, moving the property so it's further away from the properties, residences?
From discussions with the applicant, that wouldn't be possible. The project would not be able to, if further setbacks were implemented, there wouldn't be enough space for this project. But I also want to indicate that PPRP does not feel that the glare impacts provide any health or safety issues, which is our biggest concern. It's more of an aesthetic impact. And that's one thing PPRP doesn't make. We try to mitigate visual impacts, but we don't make final determinations based on pure aesthetic impacts. It's more health and safety impacts.
Okay, and I know you're going to get back to the Chief Judge Lawrence on the glare on Fannie Dorsey Road, but I'm looking at page 22 of your direct testimony, and so it says, by year 5 of operation, predicted yellow glare is reduced by 71% for Fannie Dorsey Road and 88% for OP 17. So put another way, it's going to remain 29% on Fannie Dorsey Road. And so what? And that's only in 2 months of the year, or I mean, just explain what that means.
Yes, it's mainly at 2 months of the year where the angle of the sun is less. I want to be accurate. I can't remember the exact months, but it's not going to be year round.
Right. Okay, but for those 2 months to the traveling public, that's a hazard, correct?
It's yellow glare, not red glare. Red glare is the blinding glare that we get every day from driving into the sun. It's going to just be yellow glare is just a reflection that will be seen, but it's not deemed to be
Mr.
a hazard.
Adlin, can you please?
Not deemed to be a hazard.
Hazard,
or
like
safety hazard.
A safety hazard.
Yes. Mm-hmm.
All right, that's all I have, Your Honor. Thank you.
Does staff have any questions?
No, thank you.
Your Honor, can I just clarify for bench DR1 if Mr. Adlin understands exactly what's being asked to provide on that? Is it just the glare on Fannie Dorsey Road in years 0, 3, and 5? And the months that it occurs? I want to make sure we answer the question correctly.
Yes, though I wouldn't limit it to just Fannie Dorsey Road. Any of the glare that's anticipated to still exist, as shown in figure 10. So there's a yellow line along Fannie Dorsey Road, but then also OP 17 and OP 16, and their driveway. I assume their shared driveway or one of their driveways. So anything where there's glare reflected in figure 10, the months of the year that glare is anticipated, and the minutes per day.
Minutes per day. Thank you.
I assume
Your
that
Honor.
will give me the time of day, but I can probably assume it's daylight hours.
Thank you, Your Honor.
Thank you.
All right. Thank you.
At this point, I would like to take a 5-minute break. We're in recess.
Even if you have like contours, if you kind of divide it,
I think it's just so funny when it happened, you know, yeah, I know. You're very right, but, you know.
So far, she doesn't say anything.
So you're not going to say anything?
I have two little things I'm tracking. We have one bridge DR now, but so far, other than our standard changes, yeah. I mean, we filed this in June, so that was a while back. I haven't heard anything today yet. Changes.
We're back on the record in case number 9735. Mr. Meehan.
Thank you, Your Honor. So the county filed pre-filed three exhibits. 1 and 2 were the direct testimony and rebuttal testimony of Christopher Hine, who I'll call to the stand. County exhibit number 3 was a letter in lieu of sir rebuttal testimony. I would ask that that be marked as county exhibit number 3 and admitted into record. And then
Any objections to county exhibits 1, 2, or 3 coming into the record?
No, Your Honor.
No, Your Honor.
No objections.
Okay, county exhibits 1, 2, and 3 are admitted.
All right. And I'll call Christopher Hine to the stand.
Please raise your right hand. Do you solemnly affirm under penalties of perjury that the statements made in this matter today are the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name, spell your first and last name, and give us your business address.
Yes, my name is Chris Hine. First name Chris, last name Hine, Heyn. Business address is 225 North Center Street, Westminster, Maryland, 20157.
Thank you, Mr. Hine. Did you cause to be filed your direct testimony on June 4, 2025?
Yes,
And was that prepared by you or under your supervision?
yes.
And do you have any corrections to that?
No, I do not.
And if I asked you the same questions today, would your answers be the same or similar?
Yes,
Okay. And did you cause to be filed on June 16, 2025, your rebuttal testimony?
yes,
That was prepared by you under your supervision?
yes.
Are any corrections to that?
No,
And if I asked you the same questions would your answers be the same or similar?
yes.
All right. Thank you, Your Honor. I know you already admitted them, but just I went through the litany and asked that they be marked and admitted as county exhibits 1 and 2. Mr. Hine, based on what you've heard today in the testimony that was just admitted, what are your biggest concerns about this project?
Yes, so I still have two concerns as related in my testimony, my written testimony. The first is the process by which resolution, the complaint referral process. I'm concerned about that that addresses the issues after the fact, and that I would ask, or I would hope, that these identified issues related to glare and visibility, because they are identified, could be worked out with the property owners in advance of construction and be part of the decision of the I'm not sure what you call it, the requirements of the project, as it were. The other issue relates to the glare and the glare on Fanny Dorsey Road. So my department is responsible for review of the site plan that's submitted once it enters into the county's process. And our primary concern is looking at the safety and welfare of the citizens of the county. And so the traveling public on Fanny Dorsey Road being exposed to, whether it's yellow glare or red glare, it's all distraction. And so we're concerned about the distraction to the traveling public, and would hope that that could be mitigated so that it's not a traffic hazard.
Thank you. That's all I have.
He's now available for cross-examination.
Yes, Your Honor.
Do you have any cross-examination for this witness?
Yes, Your Honor, just a few questions, please. Good morning, Mr.
Hein.
Hein,
Yes.
Mr. Hein.
Uh-huh.
My name is Andy Flavin,
Yes.
counsel for the applicant. Good to see you this morning.
Thank you.
Just a few questions for you, primarily related to your direct testimony.
Sure.
Can I ask you to turn to page 2 of your direct testimony, please?
Yes.
And starting at line 4, you discussed the reasons for the county's opposition to the project, right?
That is correct.
And you state that the primary reason for the opposition is that solar energy generating systems such as the project are prohibited in the agricultural district, right?
That's correct.
And then starting on line 13, still on page 2 here, and extending through line 17, you discussed the Maryland land use article, particularly section 4-101, right?
Yes.
And if I could ask you to jump ahead just for a moment, starting on page 3, line 2, you referenced the 2023 Maryland The Beautiful Act. Do you see that?
Yes. Mm-hmm.
And then line 5, you referenced the Maryland Agricultural Land Preservation Foundation and section 2-501 of the
Yes.
Agricultural Code, right?
Yes.
Okay. And can I get you to jump back to page 2?
Sure.
Towards the bottom of that page, around line 21, you note that the county has preserved over 80,000 acres to date of agricultural land with an ultimate preservation goal of over 100,000 acres. Is that right?
Yes.
Okay. And do you know how much of the county's agricultural land is considered a priority preservation area?
Our priority preservation area is approximately 90,000 acres. I don't know the exact number.
Okay. So it's roughly 9,000. Okay.
Yes.
And then if I could ask you to jump ahead now to page 6 of your testimony, direct testimony, please. And I'm looking at specifically on line 9, where the sentence starts, should the PSC feel it appropriate to preempt some of the county's requirements in section 158.153, at a minimum, the project should meet the baseline site requirements recently established in Senate Bill 930 or SB 931, which goes into effect on July 1st, 2025. These are the minimum standards that the General Assembly believes should be applied.
Yes.
Did I read that correctly?
Yes.
Okay. And I think, and you can please correct me if I'm wrong, you're referring to what has now been enacted as Public Utility Article Section 7-218 F2. Is that right?
I believe you are correct. I don't know, especially off the
subject
top of
to
my
check.
head. Yes, yes.
Okay.
I believe you.
Thank you. And would it be fair to say then that you're generally familiar with the provisions of Senate Bill 931 that were enacted as PUA Section 7-218?
Yes, I am.
Okay. Are you familiar with PUA 7-218 H4 Romanet 1, which states in relevant part that the total combined number of solar energy generating stations that may be approved for construction in a priority preservation area that was established before January 1st, 2025 shall be limited in area to 5% of the total acreage of the priority preservation area?
Yes, I am familiar with that.
And so can you give a rough idea of what that 5% of the total acreage of the priority preservation area in the county would be?
I believe it would be upwards of 3,500 acres, 4,000 acres, somewhere.
Okay. And just one more question here. This is more about your, I guess, your testimony just on the stand before.
Yes.
Where you're talking your concerns about glare,
Mhm.
and particularly around Fanny Dorsey Road. Did you see the applicant's proposed additional landscape buffer right along Fanny Dorsey Road to block the entrance to the solar project?
I may have. I can't recall it specifically though.
Okay. That's it for me. Thank you, Your Honor.
No cross-examination.
No redirect.
No questions.
The first page of your direct indicates on line 8 that your position as the Director of Planning and Land Management for Carroll County requires that you oversee the review of all development proposals that come to the county, correct?
That's correct.
Did you review the application filed in case number 9725, that was Chaberton Solar Pine Rock?
When you, I'm sorry, if we can clarify, are you talking about as part of the site development plan process of projects being submitted to the county, or
I think prior to that.
prior to that? Yes. As I recall, they submitted the ERD prior to the application to the PSC, and we did a review of that, a cursory review, because it's in our mind, it's not a real project until it has been submitted to the county as part of our development review process. And if I remember correctly, there's so many of these solar projects. If I remember correctly, that project has now been submitted through our development review process and is being reviewed by my technical staff. I hope I answered your question.
Would you say you're familiar with that project?
Generally.
How about case number 9746, the Elk Development Project, also north of Westminster? Are you familiar with that project?
Elk Development Project. I may know it under a different name. I apologize.
I think it's maybe the Pleasant Valley.
Yes. Yes, I am familiar with that one.
So Pleasant Valley Road is to the southwest, and Majors Drive is to the southeast?
Yes.
So you're familiar with that project?
Yes.
So in your view, can this project in this case be distinguished from either of those two projects?
I'm sorry, if you could clarify in what manner distinguished.
How about visibility impacts?
This project, in my opinion, has greater residential impacts. And I don't believe, I have not reviewed the glare analysis for those other two projects. There was a question regarding glare on Sullivan Road, which is I think it's the Pine Rock project. And so my staff has raised that question from a public safety perspective also. But in that case, that's received its CPCN, and so now we are reviewing that from what kind of comments can we make. We're new to these projects receiving CPCNs and what we can and cannot comment on.
So when you said this project has greater residential visibility impacts, do you mean in terms of the proximity of the project to I guess, residences, or do you mean the number of residences?
I don't recall the distance from those various projects to the individual residences, but certainly with the residential development that's on the other side of Fanny Dorsey Road from this project, the number of residential impact, the amount of residential impact is greater. Which, if I may, I believe, and I don't want to speak to what our elected officials' opinions are, but I believe that is why they chose to intervene on this project as compared to the other projects. The county has not intervened on those other projects.
At the bottom of page 2 of your direct testimony, when you're talking about the preservation of acres of agricultural land, is the property the project is proposed on subject to any kind of agricultural preservation easement?
No, it is not.
On page 5, when you're discussing Mr. Boswell's supplemental direct testimony, you note that the setbacks were increased from 100 to 150 feet along Fannie Dorsey Road, and the landscape buffer was expanded to 35 feet in width, and the height of landscape buffer trees were increased to 12 feet at the time of planting. Then your conclusory statement is, while an improvement, the updates do not comply with the pertinent zoning requirements. I believe you attached as an exhibit to your testimony the zoning ordinance. That's what you're speaking of, right? Section 158.153 of the Carroll County Code.
Yes.
Okay. Can you tell me which pertinent zoning requirements the project doesn't comply with?
So that would be the setback.
Which setback?
The setback, our code requires a 400-foot setback, and so does.
Is that it?
That's it, yes.
Then on page 6 of your direct testimony, you state that at a minimum, the project should meet the baseline site requirements recently established in Senate Bill 931, which goes into effect on July 1, 2025. Is it your understanding that the project at this point does meet the baseline requirements established in that?
That is my understanding, yes.
It does meet them?
Yes.
At the bottom, on line 21, are you requesting that the PSC incorporate your comments as conditions of any approval of a CPCN for the project? And you answered yes. I guess I'm not sure which are your comments that could possibly be made into conditions. Are you able to submit a list of conditions that you would like incorporated into a CPCN in this case?
Yes, we can work on that and provide that to you.
That's a bench data request to the county then, because I didn't understand exactly what you meant by the incorporating his comments as conditions. So,
Yes, Your Honor, we'll take care of that.
it'd be most helpful if it's a separate document that says county conditions and lists them.
Fair enough.
I'm now on your rebuttal testimony. Do you have that in front of you?
Yes, I do.
I'm on page 2 at the top. Line 2, you state anyone can look at the rendering of the project. Where's the rendering of the project that you're speaking of?
I'm talking more generally as far as the representation of the project through the site plans, the provided concept plans.
Okay, so you're not aware of a rendering that's available?
Not in the terminology of a graphic rendering.
So at the top of page 5, you state the only solution to the glare impacts is to relocate the project away from the residences or deny the application altogether. How far would you need to move the project away from the residences? Do you know?
I do not know.
Do you know if it's feasible?
I do not know.
Any redirect, Mr. Meehan?
No, Your Honor.
Any questions based on my questions?
No, thank you, Your Honor.
No, Your Honor.
No questions, thank you.
Thank you.
All right, thank you.
I would like to recall either Mr. Boswell or Mr. Barrett. Are they both still here? I want the record to be clear with regard to the applicant's offer to extend the landscaping buffer. I'm not sure the record's clear on the glare analysis once that change is made. So
Certainly.
Is that Mr. Boswell or Mr. Barrett?
Could we, I guess, at least start with Mr. Boswell, please? Because that was in Mr. Miller's rebuttal testimony.
You're still under oath.
Understood.
So, Connie, we good? All right. So at some point, the applicant, I guess, proposed to extend the landscaping. Can you tell me about that?
Yes, Your Honor, to the best of my recollection, that extension of the buffer pertains to the access driveway. Previously, it had been, I think, proposed to be a bit less extensive on the southwest or the western side of the access driveway, where the driveway makes a turn, and that had created a bit of an opening for glare.
You don't have a better drawing than what's attached to Mr. Miller's rebuttal testimony, do you?
I do have larger scale drawings, Your Honor.
Can you direct me to them in the record, or?
This is just a larger scale print of what was the revised conceptual site plan.
That would have been with Mr. Boswell's supplemental direct testimony, included as an attachment. Your Honor, I believe that was marked and admitted as applicant exhibit 39.
Yeah, I have it.
I'm-
It's just not going to come up very quickly.
Okay.
So what I'm looking at shows the access drive curving, and it actually comes through the 35-foot wide landscape buffer, correct?
That's correct.
So at the location where it curves and is almost parallel to Fanny Dorsey Road, there won't be a 35-foot landscape buffer, correct?
Your Honor, in the drawing that I'm looking at, we actually have staggered rows of that 35-foot landscaping that overlap at the point where the road turns and runs parallel to Fanny Dorsey Road.
Okay, so this is what's shown in, I thought it was Exhibit 40. But it's your updated site plan filed with your supplemental direct testimony. This is the extension of the landscape buffer you proposed?
That's correct.
Okay, and then did the applicant conduct any glare analysis associated with this updated plan?
I believe that was addressed in Mr. Barrett's testimony, but I'd have to defer to Mr. Barrett.
Okay, thank you.
Thank you.
Would you like to speak to Mr. Barrett, Your Honor?
Yes, please.
Okay. At this time, I'd like to recall Mr. Barrett.
So you indicated that you updated the glare analysis at some point,
That's correct.
and that was attached to your SIR rebuttal
Yes,
as,
part of the direct testimony.
but attachment 2 is a comparative analysis, correct?
Your Honor, I believe yes, so the comparative analysis was attached to Mr. Barrett's rebuttal testimony. The full updated glare analysis that Mr. Barrett performed in response to some data requests from the power plant research program, they were, I believe, included as attachment 6.2 to the power plant research program 6 set of data requests, and I believe those were included as an exhibit of selected data responses with Mr. Adlin's testimony.
Appendix A to the FAR, Exhibit 5.
So, Mr. Towson, you had the updated site plan at the time you prepared the PAR, but you didn't, I thought Mr. Adlin testified that his analysis didn't incorporate this extension of the landscape barrier.
We'd have to bring him back to the stand to ask why. I can't speak for him.
Do you know if, hang on, do you know when you did the comparative analysis that is attachment 2 to your SIR rebuttal, there was still a difference based on this landscaping extension? Is that one of the differences? And we went over all the assumptions that were different, but was the difference in the landscape one of the differences?
Yes. I guess what I would refer to is my June 30th, 2025 direct testimony. Attachment D is what I submitted as assessing the extension of the landscape screen.
Okay, the June 30th is your SIR rebuttal. It's entitled SIR rebuttal testimony of Stephen Barrett. I think it's the first time you submitted testimony, which may be why you consider it direct, right?
I guess
And then
so, yeah.
did you just said, did you say attachment D?
Yeah.
Attachment D to attachment 2.
Yes, so I'm not sure what attachment 2 is. But that-
Attachment 2 is, according to your testimony, is the comparative analysis. Do you have your testimony in front of you?
I mean, I have my.
You don't have the attachments?
I don't have them with me.
Your Honor, I have copies here if I could.
Okay. Yeah, if you could give him, because I see, attachment 1 is your, it looks like your resume. And then attachment 2 is, according to your testimony, your comparative analysis. And now you're referring to attachment, I think you mean an attachment to an attachment.
Yes.
Yes, Your Honor, that's correct. Your Honor, may I give
Yes.
Mr. Barrett a copy?
So when you, attachment D, it says modeling to assess an extension of the landscape screen using a panel height of 15 feet. You've now replicated PPRP's glare analysis, is that correct?
That's correct. And then in attachment E, I've done the same thing using my recommended 6.5 height for the panel.
Okay, what does the model show in attachment D?
It shows that comparing the PPRP's original analysis to the analysis that I presented in attachment D, the glare decreased on Fanny Dorsey Road by 25%, and I'm sorry, by 13%, and then on Shenandoah by 25%.
Can you point to me where in attachment D it says that?
Well, it says it in my, not in the attachment, but in my summary, which is attachment 2, I believe you said. In my summary, I summarize the minutes of glare reduction for Fanny Dorsey and Shenandoah, and I just calculated on my phone what that percentage was. So it's not written in my testimony.
So there's still glare on Fanny Dorsey Road and at least one receptor when you replicated PPRP's glare analysis, but with the extension of the landscaping, is that correct?
Yes, when I replicated there.
Okay, and the amounts you gave me, you said aren't in here.
Yeah, they're summarized in attachment B, which is before all of the model runs. It's under
Can you
5.0.
put-
Actually, top of page 5
Okay.
is where the minutes are.
You have, for the analysis, the replicated, you say GHG's modeling, I guess that's PPRP's consultant, with a panel height of 15 feet. Yellow glare on Fanny Dorsey Road and Shenandoah Drive remained. Fanny Dorsey decreased slightly from 1,194 minutes to 1,040 minutes. Shenandoah Drive decreased from 3,052 minutes to 2,243 minutes.
Yes, that's 13% and 25% respectively. I still contend that the 6.5 foot height is what the modeling firm recommends.
And that's what your last paragraph
So
goes
my
to.
last paragraph is related to that, stating that all of the glare is eliminated by
Okay.
the extension.
Thank you.
May I ask where you were just?
Yeah, sorry.
Oh, sorry.
You're still there.
Where were you just reading about all the minutes and whatnot? Was that on page 4 of? I got kind of long.
It's pages 4 to 5
On attachment 2.
of attachment 2.
Okay, got it.
Do you have any questions for this witness?
No.
Okay, thank you. Mr. Adlin, just in the interest of having a crystal clear record, if you could please come back up. Is it true that PPRP's glare analysis did not take into account the slight extension of the landscaping that we've been discussing.
That's correct. We didn't have our consultant available to run another analysis.
Okay, did you review the Barrett Energy Resources Group analysis?
We did.
Did you have any comments on what we've been talking about, which is attachment D to attachment 2?
We agree with that analysis. We don't have a problem with that.
Okay. Does anyone have any questions for Mr. Adlin based on my questions?
No, Your Honor.
Thank you. Believe we have oh, I'm sorry, staff. Sorry. Did you have a witness?
Yes, and before I call the witness up, may I just ask if you could mark and possibly admit 3 and 4, and they're docket number 67 and 72. Those are the letters, letter in lieu of rebuttal testimony and letter in lieu of surrebuttal testimony, and we would just ask that they be marked as staff 3 and staff 4. And I'm sorry, they're on my chart, they're the lower 2 items.
Can I take a poll? Is anyone going to have questions for the staff witness?
No questions, Your Honor.
No, Your Honor.
No, Your Honor.
Okay. Go ahead.
So we would ask that staff 3 and 4, which are the lower 2 items on my chart, be marked and admitted to the record. And then if you'd like me to call staff witnesses up so that I can ask her questions and ask that her testimonies be marked and admitted to the record. Or did you just want me to read them all off, or what's these? Yeah.
Still trying to pull up your chart.
Oh, I'm sorry.
No, that's all right.
Yeah, and I'm sorry. The chart was.
I have it.
Oh,
yeah, it's just the Wi-Fi in here isn't
right.
great. I have your chart. I have the testimonies and the letters in lieu. They are marked as you requested, staff's exhibits 1, 2, 3, and 4. And does anybody have objection if we just enter those by stipulation?
No objection.
No objections, Your
No
Honor.
objection.
Okay, staff exhibits 1, 2, 3, and 4 are admitted.
Thank you. And may I just assume that the staff's witness can be excused, or?
I don't have any questions for her.
Okay.
And no one else does either. So yes, she may be excused.
Thank you very much.
Okay, and there are no more witnesses, correct?
Correct.
Correct.
Okay, I think we have a briefing schedule.
Yes.
Does everyone wish to maintain that briefing schedule?
It's fine with us, Your Honor.
It's fine with staff. We have it.
It's fine with the county. Your Honor, when did you want the county's response to your bench request? Do you have a date in mind? Or?
So initial briefs are due on the 21st, so it would probably be a good idea to get those before that. How's October 17th?
That's fine. Thank you very much.
Same for you, Mr. Taus.
I wrote it down. Thank you, Your Honor.
Okay, anything else we need to take care of today?
Your Honor, just one quick logistical question. I understand that the PPRP may be submitting some revised licensing conditions based on your email from last week. Understanding, of course, that if a CPCN were granted, that Your Honor and the Commission could modify those conditions as you see fit. Would it be helpful to have an acknowledgement from the applicant that the applicant doesn't have any concerns with the revised licensing conditions, or is that not necessary in Your Honor's view?
No, that would be helpful. Mr. Towson, when might I see those?
Very soon. We have them ready. We held them open, as your order suggested, until after the hearing to see if additional matters came up. But if I'm correct, we can have those on file probably by Friday.
That would be great. Thank you.
Thank you, Your Honor.
Okay, anything else?
No, Your Honor. Thank you.
Thank you. We're adjourned.